Good morning and welcome. I call the second meeting of the Budget Review Subcommittee on Primary and Secondary Education and Workforce Development to order. At this time, we'll have Amy call the roll.
Representative Baker. Representative Bojanowski.
I'm here.
Representative Lewis.
Here.
Representative Raymond. Here. Representative Riley. Chair Banta.
Here. Today we have presentations from the Education and Labor Department, and they will be presenting an overview of the Workers' Compensation Program. At this time, I'm going to swear you in. If you please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Okay, thank you. As you begin your testimony, please identify yourselves for the records, and members of the committee, please hold your questions until after the presentation.
Good morning, everyone. My name is Shelby Lewis. I'm the Legislative Director at the Education. Still can't hear me?
No.
Is this better?
It has to be really bright.
It is.
Okay.
I'll press it. How about now?
Now.
Yeah, perfect. My name is Shelby Lewis. I'm the Legislative Director at the Education and Labor Cabinet.
Good morning. My name is Scott WILHOIT. I am the Commissioner for the Department of Workers' Claims. Pleasure to be here.
I'm Dale HAMLIN. I'm the Assistant General Counsel for the Workers' Claims Legal Division.
All right. Well, good morning. It's again a pleasure to meet everyone here today and see everyone. I'm proud to be in front of this committee. I come from a family of educators where education was first and foremost. My sister was a teacher. My brother is still a teacher. My mother taught in a one-room classroom in Bullitt County, Kentucky. So education has always been a core of everything that my family has been through all these years. What we're here today is to talk about workers' claims. Workers' claims is probably one of the best or the most successful combination of government and private sector working together. It has also been, since 1916 when it was created, it's also been one of the most pro-economic, pro-growth programs we have in Kentucky that not only allows continuation of our economy, but also ensures the safety of our workers across the Commonwealth. The Department of Workers' Claims consists of 6 divisions. In those divisions, we had the Divisions of Claim Processing, the Division for Security and Compliance, Division of Specialists and Medical Services, Division of Workers' Compensation Funds, Office of Administrative Law Judge, and the Workers' Compensation Board, which is our appellate panel. We also operate the second largest court system in the state. All the way across the state, when someone has a workers' compensation claim and they're litigating that claim, we have a panel of 17 administrative law judges who hear those claims to rule as to who is entitled to what benefits and so forth within the Kentucky Workers' Compensation Act. What's important about the Workers' Compensation Act is that there's 2 parts I want to go over here real quick. First of all, to the injured worker. It covers all workers with a few exceptions in the state of Kentucky. The injured worker will receive, and that means someone who has injured themselves in the course and scope of their employment with work, is entitled to medical treatment and partial wage benefits. Medical treatment probably is one of the most important things. What's key to the medical treatment that's received in workers' comp, there is no deductible. There is no out-of-pocket expense. The worker is 100% covered from the moment that injury occurs until the benefits. Before 2018, there were lifetime benefits, and now they potentially can still be, but there's a cap at 780 weeks. Workers' compensation, when I talked about before being a pro-economic, pro-growth program, it is considered because it in part is the employee's sole resource against the employer. The employee does not have to prove fault. However, as part of this grand bargain of where we have workers' compensation coverage, the important part is that for the employer has a known fixed cost as to what the potential liability will be for that injury. If you did, this is where it's different than, say, like an automobile accident. In an automobile accident, you have all those damages out there, punitive damages, mental anguish, all those, and you have to prove fault. That's not true in workers' comp. In workers' comp, the idea is to eliminate fault. In exchange for eliminating fault, the employer pays a workers' compensation premium, workers' compensation insurance coverage, and it's called the exclusive remedy, meaning that a civil lawsuit cannot be filed by an injured worker. Instead, they go through the administrative process and it gets adjudicated through the administrative law judges, as I referenced a few moments before. This program has worked. It has continued to work since 1916 for the past 106 years now going on. It's proven itself to be a valuable part of the partnership between business and the labor force. Just to run down a couple of general statistics, keep you all enjoyed on this. There are about 22,000 first report of injuries we get annually from workers across the state. This could be anything from a hurt back to a hurt foot to catastrophic injury. Anything in which an employee loses at least a day of work. Of those 22,000 claims, 12,021 result in some type of financial benefit. That could be wage benefits, the indemnity benefits. It could also be that medical care, which I just previously addressed. Of those 12,021 claims, 4,774 of the claims go to litigation, and 20% of those adjudicated to administrative law, which is about 20%, are adjudicated by the administrative law judge. Those are the claims in which they go all the way to an administrative hearing for the benefits. And of those claims, about 164 go to appeal to the Workers' Compensation Board. And not to bore you all further, but the way the process works in Kentucky, you know, in Kentucky, every citizen has a right to a civil remedy, has a right to be heard in court. The way that workers' compensation is constitutional, the way it has been since 1916, is that we have this administrative process. You go through the file of claim, the administrative law judge reviews that claim, goes to the administrative court of the Workers' Compensation Board, and then if it's an appeal from that, it goes to the Court of Appeal, which is the court of original jurisdiction, and from there, Supreme Court. But that's the exception. Most of the time, these cases are worked out way beyond that, before we ever get to that point. In addition, I'd like to go about what employers are required to do. As I mentioned beforehand, all employees, with a very few exceptions, such as agricultural workers, are covered by workers' compensation. Every employer must secure an obligation for compensation to injured employees. Two ways that's done, two ways. One is through your typical workers' compensation insurance premium. You go buy the employer buys a private policy of workers' compensation coverage, or depositing a security with the Department of Workers' Claims if you're self-insured. The self-insured employers, in which we have, Dale, we'll have about 400?
There's roughly 400 current and former self-insured.
Self-insured. Those self-insureds, they post, most of them post a bond or letter of security saying they have sufficient reserve to cover the anticipated expenses of claimants and their claims of that. Part of that also, too, that we also allow for the self-insured groups have historically been around since at least 1948, and those self-insured employers agree to be jointly and severally liable for each other compensations. We'll give you a quick overview of benefit determination. How benefits or what type of benefits we get. I've already made reference to medicals. Medicals, again, are no cost to the employee at all. No out-of-pocket, no deductible, is completely covered for all reasonable and necessary medical care. In terms of indemnity or money benefits, there are three types of money benefits which an injured worker is entitled under the Act. There's temporary total disability, often referred to as TTD. There's permanent partial disability, PPD, and there's permanent total disability, which, as you can tell from that title, is for someone who is deemed to be totally disabled, unable to return back to the marketplace. Temporary total disability is 2/3 of the claimant's average weekly wage. It's not a full wage replacement. It's 2/3 of the average weekly wage. It is paid from basically the short delay pursuant to the Act for the claimant during the time that claimant is recovering from the effects of the injury. So that, for instance, if you had a surgery, or you had a broken leg, or you cannot go back to work, or can't during that period, you get your TTD, which is 2/3 of your average weekly wage. Once a claimant, when one of two events occurred, either they reach a condition called maximum medical improvement, MMI, or they return to work. Once that occurs, they can either say, okay, thank you, that's all I want, or they have the right to pursue a permanent partial disability, a PPD. And the way the PPD is determined, we have a formula in this book under KRS 342-730 that takes the percentage of disability. It's a big, thick green book called the AMA Guides to Impairment. And it lists everything from a broken toe to something wrong with your head. And it lists different body parts, what that percentage would be to the whole person, to that part. That number goes into a formula that's set forth in the Act to make a determination as to the level of permanent partial disability benefits that claimant is entitled to. If it's less than 50%, the claimant receives a total of 425 weeks of PPD. If it's 50% or more, they receive 520 weeks. If it's a total award, and there's some few statutory provisions of what actually equals a total. For instance, blindness, double amputation, some of the truly catastrophic. And it doesn't have to be those statutory ones. It can also be deemed if a person's just the ALJ administrative law just find that based upon the person's education, health, age, so forth, that person cannot return to work. They then get what's equivalent or close to that TTD amount for their life, for the life expectancy. So we have 3 types of benefits that are designed to do. I say all this, and keep in mind what we are really trying to do with workers' comp. I talk about the total claims. What the whole goal of workers' comp, the main emphasis of workers' comp, is to get those injured workers back into the workplace. We have benefits set up such that we have rehabilitation services. We have benefits set up so we can help that worker to get him back into the workforce. The vast majority of workers out there who get injured do in fact return to work. For those workers who cannot return to work, we have that safety net, that permanent total disability award. If the judge finds that for those individuals. But again, what's important for the employer knows what those damages, what that cost is going to be, because the employer pays a workers' comp premium and doesn't have to wait for the results and see what happens with the roll of dice with a jury in a civil case. And that's where you can see what the true benefit was called the grand bargain, what workers' comp encompasses. Also, in regard to medicals and workers' comp are governed by a fee schedule. So that, if you all get your insurance, I have some explanation of benefits, and the insurance company says this is how much the charge may be X, and then we actually pay Y. Same thing true of workers' comp. There's a published fee schedule we put out every year that says this is how much is the accepted normal rate we will pay for medical benefits for whatever the treatment may be at that time. System that has worked and continues to work for all our folks. I'm going to go through briefly real quick and talk about the history of the special fund. It's been called by different names over the years, but the first part I want to stress is that the special fund was created in 1946. It had a different name at that point. At that time, it was called the Second Injury Fund. And it was designed with the idea we had all these veterans, many of them disabled, returning from war in World War II. And it was difficult for some of those employers to say, well, I don't know if I should take this worker. He's got problems. He's got issues. Am I going to be stuck with the medicals for this individual? So instead, as an incentive to bring those workers into the work, the state created the Subsequent Injury Fund to help create. What it basically meant was anything that was a pre-existing dormant condition that occurred not because of an accident at work, but the state would pick up that dormant part of it, and so only the part that's called the active condition that occurred by the injury. Most common example of a pre-existing dormant condition, I've been practicing workers' comp for about 33 years or so. The number one we always used to see are back injuries. Your back may hurt, you may have had back problems, you may have underlying degenerative disc disease in your back. You're able to work, you're able to do your job. However, you have an accident at work and now you can't. Well, what the determination of a pre-existing dormant condition is, what part of that is attributable to this dormant condition that existed before the injury, and what part was aroused into a present-day disabling reality by the injury itself. That's what I mean by a dormant condition that kind of segregated out that part of it. The special fund, or the secondary injury fund, was expanded in 1960 to cover those pre-existing dormant conditions. It was renamed the special fund in 1964. Just to go through some more name changes it went through. But probably the biggest change in terms of that special fund that covered those pre-existing dormant conditions came as a result of the extraordinary sessions that took place in 1996. At that time, the General Assembly decided we're going to eliminate the special fund. It was abolished. There were no new claims after 1996 for the special fund. But what's important is there are still a lot of claims out there from before 1996. So I'm going to be coming back and talking about the special fund here in a minute. But I just tell you, there are no more new special fund cases, but we are still taking care of those to whom we made that promise, who had injuries before 1996, to which we're still taking care of. And lastly, in 2000, it was changed. It was named to the Division of Workers' Compensation Funds. I'm going to refer to it from here on out as a special fund. That's the way everybody refers to it still, and that's what you'll hear when I hear it today. If you hear the different terms, you see that term, it's the special fund on that. Just a couple of statistics, I won't bore you completely with this. Back in 2002, we had 11,600 claimants and beneficiaries, and $90 million were paid in benefits. Over the course of 20 years, excuse me, that number's been going down. It continues to go down. In 2022, we had 34 claimants. We paid approximately $34 billion paid in benefits. Now, these last two numbers I want to talk about in a second. Let me take a drink of water here if I may. Our fund, what we do, I'm taking a little bit out of order, but I want to address this. The special fund is able to do what it does because of two things. We're going to talk about an assessment that comes on the premiums. Every time you buy a workers' compensation policy, there is that premium, there is assessment contained on that policy that goes to help fund the special fund and the operations of the Department of Workers' Claims. Why that's important, too, is not only for the operations department claims, but to make sure there are sufficient funds to cover these claimants who are still out there to make sure we have that. The goal being that, according to statutory, that it's called the sunset provision. The sunset, this assessment is supposed to sunset on December 31st, 2029. We have projections, we have actuaries where we invest that money that comes in. It's invested to make sure there are sufficient reserves to cover those expected costs. So again, the idea being we're going to keep that promise made to injured workers. That money is all invested and is governed by the funding commission, whether they do there. But it's not just a special fund. With the special fund's current liability of $511.5 million for the special fund, but also $89.5 million for the Uninsured Employers Fund. Let me quickly tell you about the Uninsured Employers Fund. That's another fund out there. Now, as I mentioned earlier, everyone in Kentucky is required to have workers' compensation insurance. Every employer is required to have workers' comp. Well, unfortunately, not every employer does. And we have a division, a security enforcement division, that goes around and spots checks on leads to make sure that employers have their workers' comp coverage. But unfortunately, we can't find everyone. There's always going to be some that do not. Oftentimes, it's businesses that are struggling, or ones that really can't, they're cutting costs or so forth at that point. But again, we're required to have special fund. And oftentimes when I talk to folks, individuals say, well, do I really have to get special? Do I have to get that workers' compensation? So number one, it's the law. But number two, if you don't get it, you don't get the protection of exclusive remedy. If you don't get it, your injured worker no longer becomes your injured worker. Your injured worker can end up owning your company from filing a lawsuit against you for personal injury and damages. So they usually see that's a great bargain to get a workers' compensation coverage as opposed to going through this. But what we do have for those employees who are injured on the job and their employer did not carry mandatory workers' compensation coverage, we have the Uninsured Employers Fund. It's actually a division that's run by the Attorney General's office. And what they do, if a claimant gets injured on the job, let's say by Bob's Tire Service or Bob's Tree Service, you pick. It gets injured by the job, and Bob's Tree Service or Bob's Tire Service doesn't have workers' compensation coverage. Somebody's got to pay that bill. So what happens is the Uninsured Employers Coverage Fund comes in and acts as a substitute to step in as the surrogate or as the statutory substitute to make sure the benefits are covered. And what it does, it pays out benefits as if it was the employer. Now, what the Uninsured Employers Fund can also then too, it can then go back after that employer and get dollar for dollar the money that was paid. Unfortunately, often what happens is those are businesses that don't have the resources. So that's why we end up having this assessment. If it was a dollar for dollar, we could go back and get every single dollar that was paid out. Great. In the real world, it doesn't happen that way. So part of that assessment that goes on that premium goes to fund the Uninsured Employers Fund to ensure that that safety net is still there for that part. So I wanted to explain what the UEF is in the workers' comp. All right. I'm going to switch gears here just a little bit and talk about guarantee funds. I'm going to talk about three types of guarantee funds. Guarantee funds are part of the Workers' Compensation Act. They were created in 1996. Three types of funds. We have the Kentucky Individual Self-Insurance Fund, we have Kentucky Coal Producers Fund, Self-Insurance Fund, and the Kentucky Group Self-Insurance Fund. What these funds did, or amalgamation would allow these self-insurance groups basically to get together and pool their resources, in essence, to take care of any claims that come from these resources. Of those three groups, the Kentucky Self-Insurance Fund, Individual Self-Insurance Fund, the Coal Employer Self-Insurance Fund, they all are under control and regulation, so forth, watch of the Kentucky Department of Workers' Claims. We require that they maintain security. We watch that security and make sure that happens. One group is outside the Department of Workers' Claims. That is the Kentucky Group Self-Insurance Fund. And I won't go into all the problems with that and just tell by my words. There's some issues with that. In fact, we were here last week testifying about that group insurance fund, where there's some issues with that group fund and whether or not they have sufficient security. That is the one fund that we don't govern and one fund that we don't maintain. We don't have a watch over security over that. And they do not deposit security in that. And that's been problematic and continues to be. In fact, there's some, again, they are looking at resources, different available means for that one particular group and what that comes to. When I talk about these self-insurance funds, you're going to hear, and you may hear in the news, you may hear from other information, about an important date. That date being March 1, 1997. Why is that date important? It is the dividing line. It is the time in which delineating on who is responsible for what claims. Prior to March 1, 1997, the guarantee funds were only responsible for claims, after March 1, 1997, the guarantee funds take care of those claims after that point. Before March 1, 1997, there was a problem. There was no safety net after the group to take care of those individuals. Well, what we did, we ended up creating to take care of that was called the 920 fund. In fact, actually, I'm going to get, I kind of skipped here just a little bit. Let me go to the 920 funds. Two more. There we go. Thank you. The 920 fund, it's got a creative name because the 920 refers to the statutory reference. It's KRS 342.920. Hence, we call it the 920 fund. Not very creative, but that's what we refer to as the 920 fund. The 920 fund was created for the purpose of making payments to employees injured before March 1, 1997, when the security of formerly self-insured employer has been depleted. It's a safety net. It's another one of those safety nets. You keep on hearing me talk about that. We have to make sure what Department of Workers claims, kind of like what Social Security does, we are a safety net for injured workers. We are a safety net for our fellow Kentuckians who sustain a work-related injury. We're the ones who are there to take care of those workers. Now, the 920 fund is funded not through general funds and not through the assessment of the premiums, assessment on the premiums. It's funded by penalties collected under the UCP, Unfair Claims Practice Settlement Act. And it's also funded, when I talked about a few minutes ago, when we go out and find employers who don't have comp, well, one of the things that happens is that they get fined. And we fine those employers. Our fines range, they spread the gamut. When I issue a fine, we also, of course, they get entitled to due process on that fine with a hearing. Those fines are usually, it depends on several factors. Are they a repeat offender? Are they, how long have they gone without insurance? Is this not an accident, but going on and over again? And also, too, did we find out about this because an accident's occurred? All these factors go into the formulation of what size the penalty is and the difference in the penalty, too, on the type of work it is. The type of work kind of like reflective of the insurance rate. Someone who is trimming trees or working electrical lines has a much more dangerous job than someone who, well, like me sitting here talking with you here today. There's a difference between that. So our penalties and assessments are based largely taking those factors into consideration. That 920 fund is funded through that safety net is funded through the assessment of those penalties. I will tell you in all honesty, I hope that fund from the 920 fund from penalties goes down. I'll tell you why. That means we're having fewer and fewer employers who are not going out there without employment or going without insurance. Is the goal, if I could wave the magic wand, that 920 fund from penalties would be zero, because that means every employer's got workers' comp coverage. Well, that's maybe a pipe dream, but for right now, that's just giving an idea that the goal is to get more companies to be employed or to have workers' compensation coverage. Now, we receive about $1 million annually from penalties and so forth with the 920 fund. But we're paying out about $1.2 million annually. So you'll see there is a shortfall because we're paying out more than we're collecting. That's why in 2023 there was a year-end appropriation, one-time appropriation, of $3 million to help buttress this fund to make sure that safety net is also well funded with that. And I'll come back to the appropriation here in a few minutes. I made reference a few moments ago to the Funding Commission. The Funding Commission is the group, is a division that oversees the collection, investment, and distribution of the funds that are collected via the assessment on the premiums. The money that's received from those assessments, they go to fund the Workers' Compensation Funding Commission. They also fund the Department of Workers' Claims. They also go on to fund the Kentucky Occupational Safety and Health and the Uninsured Employers Fund, which I just spent some time describing what they are. All key divisions that all combine to help make sure that the Department of Workers' Claims, or that workers' compensation in general, is there to protect workers. That funding source, again, as I keep on referencing that assessment right now stands at 6.94%. Incidentally, something that we're proud of saying, that assessment rate has continued to go down, go down, go down. Also, the premiums for employers have continued to go down, down. I think we're now going into our 17th year of workers' compensation insurance premiums are going down. Many factors for that, including safer workplaces, employers being more attentive to the safety of their workers, but also too, just that we keep on going down. That's a good sign. That's a good thing that we do. And again, with that assessment on that premium dollar, it goes to fund those various divisions of the Department of Workers' Claims. I want to go on and talk about additionally what the Workers' Compensation Funding Commission, what the money goes to, as well what projections are. A few moments ago, I talked about this sunset provision, which we've got to make sure that there are sufficient monies there to cover the special fund claimants, those 3,000, roughly 3,100, 3,400 remaining claimants. Again, the money is collected. Part of that goes to fund the special fund. So I'm using the word fund. It gets confusing because we keep on using the word fund, and we use it repeatedly in different manners throughout this discussion. It goes to help fund that special fund to make sure the money is there. It just doesn't sit there in an account. It sits there and it's invested, and the returns from that investment are all projected through an actuarial table, through actuaries that we retain, to make sure there's sufficient funds, that being the $511.5 million, as well as the UEF at $89.5 million, sure that money is there. We have meetings all the time with the actuaries. I think we meet 4 times a year to check on those investments, how they're doing, and go by that. The Funding Commission is responsible for making sure it is properly funded and from there with it. Now, I'm going to come back. I'm going to talk to you. All may remember, it's been in the news for quite some time, and it continues to be in the news. AIK, it's called the Associated Industries of Kentucky. AIK Comp has been in the news since about 2004. Well, it actually started in 1979. The AIK Comp was established in 1979 as a selective self-insurance fund. The AIK Comp, now, it ran into some problems. It was in the news, all the headlines and so forth. They ran into problems. It was placed in rehabilitation on August 5th, 2004. AIK Comp then ceased to write any new business as effective February 28, 2005. But AIK Comp wasn't alone. There was another company too. The Kentucky Coal Producers was formed in 1981. KCP, as it's referred to, ceased accepting new members and began winding down affairs in 1991. In 1995, KCP sought bankruptcy protection. In 2015, the Department of Insurance and the Department of Workers' Claims entered into a memorandum of understanding to use the 920 funds to pay the KCP claims that arose before March 1, 1997. Why is all this important? Well, we had to make sure there was money. These two entities were running out of money. We had to make sure these injured workers were paid and taken care of, make sure the medical care was taken care of. In 2022, it was brought to it that what we were trying to, there was insufficient money in the 920 fund to continue to cover the AIK situation, the KCP's operation. The Department of Workers' Claims came to the General Assembly and asked for an appropriation, a one-time appropriation, which was approved. In fact, the governor asked for it, and the General Assembly approved that appropriation. A large part and that was for $23 million. Of that $23 million, approximately $14 million went to cover the KCP pre-March 1, 1997 claims, as well as the AIK pre-March 1, 1997 claims. That made up about $20 million. It was sold, and it wrapped up in a package and sold to KEME, Kentucky's Employer Mutual Insurance Company. And basically that liability was capped, and now KEME controls that, takes care of that to the end of the claims. It will no longer be a drain. It will no longer be a problem to be funded because it was wrapped up in a package called a lost portfolio transfer to KEME, and that was taken care of. The $3 million extra that we talked about before, that's why I referenced earlier, it was sent to bust up the 920 claim because those two entities were chewing up the money faster than we could collect. We couldn't get enough money to do that. So the good news is that that's now capped out and done. The KCP and the EIK pre-March 1, 1997 claims are no longer a responsibility of the Commonwealth. They're now being administered and taken care of by the state. As I come to conclusion, I want a couple of things to tell you all about. We are coming again, I may reference the sunset date of December 31st, 2029. Why is that date important? All the funding that I've talked about, the funding for the Unemployed Insurance Fund, the funding for the Department of Workers' Claims, the funding that we do to make sure that workers and claimants get the protection they need, to get the benefits they need. Everything is funded, not through a general fund, but through that assessment, that premium. By statute, that premium is set to come to an end. That assessment is set to come to an end on December 31st, 2029. That may seem far away. It's not. So the questions we have to start thinking about is, okay, what are we going to do in the meantime? What are we going to do when December 31, 2029 comes about? Hopefully we'll long since talk about that, what will be in there. But the key to what I want to sum up with talking about workers' claims, it's not just to take care of injured workers, which it does, and it does well. It does really, really well. Incredible program. But I'll stress to you all, is probably the most pro-economic growth program we can have in the state, because it makes sure that employers are covered. They don't face extreme liabilities, extreme risk. Their risk is set. Their risk is known. So it allows continuation of growth, and why Kentucky continues to remain such an attractive state to outside employers coming in. Because I'll say with pride, and I am biased in this, I've been practicing workers' comp again for about over 30 years. We have one of the best systems in the state. Injured workers are taken care of, employers get a fair shake, employers know what their policy is, and we continue to see our premiums going down. All those things is what goes into making Kentucky workers' comp a success, and I hope we continue for another century, another 106 years and beyond. Thank you. Any questions, please?
Thank you. I see one question. Go ahead.
Thank you all for the presentation. Just so I'm clear, and of course we hear all kinds of different things when we're up here and from some of the people back home, but there's some talk out there that maybe the self-insured workers' comp fund could be insolvent by as early as October of this year. Is there any truth to that?
That's a good question, and that was here last week, testifying to another company about that very nature. You are correct. Of those three groups we talked about, the self-insured the self-insured individual fund, the Kentucky Coal Producers Fund, the two funds that the DWC regulates, and then the Kentucky Self-Insured Group Fund. Representative Lewis, what you're referring to is the Self-Insured Group Fund.
Correct.
And that is the one that, according to their projections, that they will run out of money in October, and they are looking for an appropriation. Again, it's the one that's outside our purview. We just, by the way the law is written, we don't have the opportunity to review or to hold their security. Representative Lewis, you are correct. And it's difficult because from my standpoint, what I care about is what happens to those injured workers. And I don't know if we want to go into today or give that self-insurance group an opportunity to explain to themselves why they got in this position where they are now. But the end result is, as Commissioner for Kentucky Department of Workers' Claims, I'm concerned what comes after October to make sure there's money for that. Go ahead, Dale.
Okay. One of the things that we didn't quite mention, we kind of skipped over it, was that back in 2004, regulation of the actual workers' compensation self-insured groups was moved by executive order over to the Department of Insurance. And that's kind of why the commissioner keeps saying that we don't regulate them. That's why. They got moved over there. And each of those guarantee funds, we hold security on each of the individual employers, we being the Department of Workers' Claims, on each of those individual employers. So if that employer fails, they default in some way of being a self-insured employer, we call that security, and that gets transferred over to the appropriate guarantee fund. That guarantee fund then pays the claims as far as that security goes. And it usually covers all of it. But if it does not, then what they do is they assess their members in order to pay those claims. What happened in this case is that security that got transferred over to DOI way back in 2004 was probably used during the rehabilitation or the liquidation of those two entities. So there wasn't any security to actually call and give to that group, the fund, the guarantee fund. And so they find themselves in a situation where they have to immediately assess. The other two groups, and I can't speak to the group guarantee fund because I don't have a lot of contact with them. But with the others, what they tend to do is they kind of keep an eye on things and they start actually assessing themselves early on in anticipation that there may or may not be enough funds available. So they begin that process, and apparently this group did not.
One follow-up, Madam Chair.
Yes, please.
So I guess my question to you all would be, do you all have a solution?
Well, I pause because right now, statutorily, the way the system is set up, we do not have a means. The 920 fund is not designed to pay for those are all post-March 1, 1997 claims. We do not, the statute that allowed us to pay for the pre-March 1, 1997 claims through the appropriation through the General Assembly was for those, again, for those before March 1, 1997. We were permitted to do that. Right now, we don't. There is not a fund. And that's where my concern comes, Representative Lewis, that we don't have a means to do that. So the concern is what happens then come either October 31st or November 1 of 2023. Now, the available things to the group fund, what they are doing there, I believe they are seeking an appropriation from the General Assembly. They also have, as Deputy Commissioner Hamlin has also referred, they have assessed themselves. There is a possibility too to look in if they can secure a loan to take care of those resources. The problem also with the group, when the group started back in 1997, the self-insured group fund, I believe there were 14 members. They're now down to 2 or 3 members of that group. Most of them have gotten out of the group and so forth. It's difficult that in terms of, and I can't go into details of why they did not assess themselves more during that period and so forth, knowing that AIK is sitting out there. But at the end of the day, we can go back and looking back and forth of why they did not assess themselves. At the end of the day, someone's got to take care of those injured workers. And you asked a very fair question, what's the solution? I'm worried. I'm worried about that. We got either through either an appropriation or that the group fund's going to have to come up with some sort of resource to take care of the workers. Because right now, there is nothing within the Department of Workers' Claims that allows us to do it. There's not a statute, not a regulation, not a fund, a pool that we can dip into to say, take care of that medical needs for that injured worker.
Keep going.
It's, I just keep
I understand.
more and more questions, but I guess my question, October is going to be here before we know it. So I'm assuming that people are working on this issue to come up with a solution.
They are. When we were here last week, again, the spokesperson for David Whitty spoke before the committee last week, and they're looking for a couple of resources in that. One thing we looked at, what they discussed was what will it take to get them to the next appropriation, to get to the next General Assembly, to get to 2024, the next big session in which they can open up the budget and look at that. And I believe the money they were talking about ranged anywhere from $550,000 to when was it 1.4?
That's what I recall.
1.4 million to get them at least through July of 2024. That meaning they come back and explain in more detail to the General Assembly what they need to do for that. We are working with them, have been working with them, and have been making strong suggestions. Here again is one of the problems with that. On those other funds, those other group funds, we do regarding that security. On the group funds, I'm an ex officio non-voting member of the board, which means I have zero ability to say, hey, you need to do this, you should do this, you must do this, order them to do this. I simply don't have that authority. The statute doesn't permit that, nor for the Department of Insurance, Commissioner Sharon Clark. Both of us can sit on that on the board with that group, but we can't force them. We can strongly suggest, and trust me, we have, what they need to be doing, but that's about the extent. But it's the thing that can keep me up at night.
Thank you.
Any other questions? Yes, Representative Bojanowski.
Okay, I'm just trying to wrap my head around all this, and it's a lot. I know when we had a small business, we paid KEMI lots of money for our workers' comp. That's all I know about this. So are these guarantee funds, are these for-profit corporations? Are they nonprofits? Are they something altogether?
Go ahead.
I'll address that if you like. They are not for-profit at all. What they are basically other self-insured employers. Every self-insured employer on March 1, 1997 was automatically a member of one of these guarantee funds. And again, the way it's supposed to work is where each self-insured, it's only self-insured employers. Employers who purchased a policy like you did through KEMI, they're guaranteed by the Kentucky Insurance Guarantee Association. A different guarantee fund, if that makes sense. These are just for self-insured employers. And to be self-insured currently in Kentucky, you've got to have like $10 million in assets above your liabilities. And I mean, it's a big hurdle to become self-insured now. Back in the past, it was not necessarily the case. And I mean, people have been able to self-insure since pretty much the beginning of this program. So there's some very old former self-insured employers out there. Current self-insured employers, we actually take a look at all their incurred losses annually, and so we make sure we've got sufficient security for them. The real difficulty comes in some of the older ones that have left self-insurance or don't exist really at all other than pay these claims. But what happens then is if they default, we do call that security. That security money gets used to pay claims. If that security proves to be insufficient at that point, each member of that particular guarantee fund then is assessed, and they, like I said, they usually start much earlier than that. But they pay out of what they call member assessments, and that pays the remaining claims all the way out to their end, to the end of that claim. So it's a little different than if you buy a policy. Does that make sense? They're no profit at all. It's literally everything has to be gone or used to either pay a claim or the administration costs of basically paying a third-party administrator and that sort of thing to pay the claims out.
If I may.
Yes.
So, I mean, somewhere actuarially something went awry, right? Do these self-insured groups need different oversight? Do we need to not allow for self-insuring? I mean, this kind of comes into what a solution may be. I mean, here we are, and these groups made mistakes, and they didn't collect enough money to be able to pay the claims that they have to pay. And so we as taxpayers may need to take care of our people, which we need to do, but do you kind of see where I'm going?
I think a couple of points, and please, I'll let Deputy Counsel, General Counsel Hamlin explore on this. One thing I want to say that as a positive, and I'm not negating at all about this, the group individual fund. The other two funds are operating and operating well. There are sufficient funds for the self-insured individual fund, and there are sufficient funds for the Kentucky coal producers for the coal producers fund. It is this third group, the group individual fund, about where the problems lie with it. And answer your question, perhaps yes, in terms of regulation of that, because they are different from the other two, than what the other two groups that we do regulate and the securities required. But also at this point too, we're only talking about 2 or 3 members of that group even still exist. What that solution may be, what that solution for that group, for that individual, or excuse me, for the group fund, I think oversight would help with that. But I'm confident that with the other two groups, we're not experiencing these issues with that. And Dale, I defer to.
That's correct. It's hard to turn something off once it's on. So these incurred liabilities, as you may have heard earlier, some of the medical benefits especially tend to last years, long time. You may get a new knee today and you don't need a new one for 10 years or 15 years, but when that comes, workers' compensation still pays for that. And so we could just say, oh, we're all done. but that really is not going to solve the problem because there's still those ongoing liabilities. So it's a longer term solution than that, I think, is probably needed. And like I said, it may in essence, take care of itself to a degree in that there may not be any more group self-insured employers. Or, they may just go away. There's only 2 left, or 3, 2, I think.
But unfortunately, of those 2, there's still got what we're talking about, the AIK claims, basically from March 2nd, 1997 going forward. Those are the claims that are out there that we're worried about, along with the other claim. But the majority of those AIK went belly up with that. That's it's a reference. The same thing too. Like we haven't taken new special fund cases since 1996, and we still have 3,100 claimants for which we're responsible for the medicals on those individuals. Thank you.
If an employee passes, do the benefits go to the beneficiaries or do they cease?
Good question. We have a whole formula in which when an employee, there's two answers to that. Typical lawyer will give you 2 answers to as a simple question. There's 2 mechanisms by which we have a scheme for an employee who passes. If an employee passes because of a work-related injury, he's killed on the job, we have one statute that says, here are the benefits, including a lump sum debt provision for that employee. I think right now it's about $99,000 of lump sum benefit that goes to the estate of that injured worker killed on the job. And also then it passes down. We have a whole mechanism who gets those benefits. I think more of the question you may be asking is someone who has received workers' compensation, say for 425 weeks or for a total, what happens when they pass? And yes, we do have provision, and that provision states that they can do what's called a substitution of the party. It's a Form 11, substitution of party, and the widow gets, I believe, 1/2 of the benefits of the expected life expectancy. So it does pass on not only to the widow, but also if there are dependent children under the age of 18, or if there are some other special needs for someone of that nature. Good question.
Thank you. Any other questions? And just for the committee, next Tuesday. Oh, it's tomorrow?
The Economic Development Public Protection Subcommittee.
The Economic Development Subcommittee is going to have the, I don't know what to call it, the self-guarantee problem presented to it. So
Okay,
we'll hear
very
more
good.
about that then. Any other questions? Okay, I need to approve the minutes from last week, please. Minutes are approved, and if there are no further questions, we are done. Thank you so much. Thank you for your presentation.
Hey, thank you very much. I appreciate